For over 50 years, American conservatives built an entire legal movement around originalism, the idea that judges must hold, above all, to the original meaning of the Constitution. We told ourselves that if we just appointed enough originalist judges, the country would course correct. But here we are. We win cases, but we lose the culture. We celebrate narrow victories while watching the foundation of society erode. What if originalism solved yesterday's problem and left us defenseless in today's civilizational fight? So tonight, I want to make a case that conservatives need to move beyond originalism, recover the classical rule of judging, and finally stop pretending neutrality will save us. Because it won't. Welcome back to The Restless Signal, home of the War of Ideas. Support our mission by subscribing now. If you've been following this show, you know I keep coming back to the same reality. We're living through a war of ideas, not just in elections or media, but inside institutions themselves, inside agencies, inside courts, inside bureaucracies, inside every place where so-called managers, what others might call knowledge workers or professionals, quietly wield power to impose ideological outcomes, whether they recognize that's what they're doing or not. Last week, I talked about why conservatives keep failing to govern even when they win elections, because the conservative coalition doesn't actually agree on what it's fighting for or how state power should be used once they have it. Some want conservative traditions. Some want maximum liberty. Some want procedural restraint. And many are deeply uneasy about exercising government authority at all. Progressives, they don't have that problem. They have shared goals, and they're very comfortable using state power. As a result, they're far more effective at turning their election victories into policy. Tonight, I want to show that the exact same asymmetry exists in our courts. Conservatives built a 50-year legal movement around originalism, a legal interpretive methodology rooted in restraint, neutrality, and procedural legitimacy. It focused on anchoring constitutional interpretation to the original understanding of the document, as best as it could be understood using the good faith application of legal and historical tools. Progressives, meanwhile, treat courts as tools of societal transformation, using whatever interpretive tools are available to them to reach the outcomes they want. And while originalism has delivered some conservative victories, game theory shows us that when one side treats rules as binding and the other treats them as optional, the rule follower doesn't get any credit. They eventually lose the game. So the question isn't whether originalism is a more honest interpretive theory than progressive judicial activism and the living constitution theory. It clearly is. The question is whether it's enough to win the war of ideas. I'm going to argue that it isn't, and the conservatives need to recover a much older understanding of judging, one that's honest about power, grounded in moral responsibility, and oriented towards justice and civilizational survival. But let's start with how we got here. For about 50 years, conservatives poured enormous energy into one project, building an originalist judiciary. Law schools, clerkships, think tanks, judicial pipelines. This was disciplined, patient, institutional work and had a clear purpose. To understand why originalism emerged, you have to understand what the court changed from. In the 19th and early 20th centuries, American law was dominated by a kind of legal formalism, the belief that judges could take statutory or constitutional texts, apply facts, and mechanically produce the correct answer. Law was treated almost like math. Plug in input, get the results. That picture was always too simple. And by the early 20th century, legal realists had convincingly shown that judges inevitably exercise discretion and that outcomes are shaped by values, context, and judgment. The legal realists were right about that. But what happened next is the critical move. Instead of re-anchoring judicial discretion in moral responsibility and institutional limits, by mid-20th century, courts increasingly embraced their role as policymakers outright. During the era of the Supreme Court led by Earl Warren and continuing into the Burger Court, the Supreme Court stopped behaving primarily like an interpreter of law and began acting like the driver of societal transformation. Now, this wasn't grounded in a single clean interpretive theory. It was a loose blend of post-realist pragmatism, purposivist reasoning, and open-ended judicial discretion, wrapped in the language of professional craft and legitimacy. The basic idea was that judges could responsibly update constitutional meaning to reflect modern values and societal needs. Courts openly reasoned about consequences. They treated statutes and constitutional provisions as flexible instruments, and they increasingly saw themselves as authorized to resolve major moral and political questions directly, rather than leaving those questions to democratic processes. You see this most clearly in cases like Griswold v. Connecticut, where the court famously discovered a constitutional right to privacy in the penumbras and emanations of various amendments in the Bill of Rights. And later in Roe v. Wade, where the court constructed a nationwide abortion regime with almost no grounding in constitutional text or historical practice. Whatever one thinks of the outcomes, these were sweeping political settlements imposed by judges. They bypassed legislatures entirely and reshaped American life by judicial fiat. This is the environment that produced Robert Bork. Bork was a Yale professor, a federal judge, and later a Supreme Court nominee. But most importantly, in the early 1970s, he became the intellectual center of conservative resistance. He wasn't reacting to abstract philosophy. He was responding to a court that had quietly transformed itself into a kind of mini super legislature, while still claiming legal neutrality. His warning was simple. If judges are free to invent rights and update meaning based upon their own sense of justice, democracy collapses into judicial oligarchy. That critique was then operationalized by Supreme Court Justice Antonin Scalia, who translated it into a usable judicial method focused on text and original public meaning. And further, this approach was institutionalized by Edwin Meese, who brought originalism into President Reagan's Justice Department, his judicial nominations, and the broader conservative movement. Originalism was meant to be a restraint project that sought to reboot the judiciary to something closer to the traditional role it had in America. It was a serious attempt to redemocratize law, to take power away from judges and give it back to the people through their elected representatives. It tried to replace judicial will with method. It tried to bind judges to something outside themselves. It assumed that if everyone played by the same rules, the system would stabilize. And in the world it was built for, maybe that made sense. But originalism was designed for a legal environment where judges still believed they were neutral magistrates, where institutions shared loyalty to constitutional order, and where restraint was assumed to be mutual. That rule doesn't exist anymore. Maybe it never did. And that's the crack. Everything else is falling through. Originalism assumed something crucial, that judges, even when they disagreed, are fundamentally trying to be neutral magistrates. It assumes shared institutional loyalty, good faith disagreement about meaning, and mutual restraint. That assumption no longer holds. What unifies modern progressive judging is not a particular interpretive theory. You'll hear references to living constitutions, purposivism, critical approaches, and so on. But none of these actually bind progressive judges in practice. Instead, there's a much simpler operating principle: outcomes first. Progressive judges begin with a result they believe justice requires, and then work backwards to justify it. They will use text when it helps. They will use history when it helps. They will invoke purpose, evolving standards, or social consequences when those help. Method is a tool to them. The outcome is decisive. On the left, interpretive theory is a toolkit. On the right, it's a straitjacket. You can see this clearly in Bostock versus Clayton County. There, the conservative Supreme Court held that Title VII's prohibition on sex discrimination included sexual orientation and gender identity. This result was justified through an aggressive, literal form of textualism, even though Congress has repeatedly declined to adopt that interpretation, and even though everyone understood in 1964 that the word sex referred to biological sex and not gender identity. Progressives suddenly embraced hypertextualism because textualism delivered the outcome they wanted. And also notice something important here. This wasn't just progressive judges in this case. The majority opinion was written by a conservative, Justice Gorsuch, and the progressive justices joined his opinion. He reached his decision using textualism, not originalism exactly, but a close cousin, a methodology that conservatives also rely upon. In other words, conservative techniques applied in good faith by conservative justices was used to produce a result that advanced progressive ideology. That's the deeper problem. It shows that even when conservative justices and judges play honestly by their own rules, those rules can still be turned against conservative civilizational outcomes. Method alone doesn't protect you. Neutral technique doesn't guarantee moral direction. That tells you everything you need to know. Even when they hold power, they rule narrowly. They avoid resolving fundamental questions. They hesitate to impose broad doctrines. They treat their role as minimizing disruption rather than shaping outcomes. A perfect example is Masterpiece Cake Shop versus Colorado Civil Rights Commission, where a Colorado baker had been fined by the state government for refusing to bake a wedding cake celebrating a gay marriage on religious grounds. The court ruled in the favor of the baker, but only on a narrow grounds related to hostility towards the baker's religion, demonstrated by state officials during their hearing on the matter. The court explicitly declined to resolve the core constitutional conflict between compelled speech, religious liberty, and anti-discrimination law. The result was a technical win that settled nothing. The baker faced years more of litigation. Similar cases kept coming across the country. Lower courts continued punishing religious dissent. In contrast to conservative restraint and the mixed outcomes originalism delivers for the conservative coalition, progressives often embrace pure judicial activism, using whatever interpretive tools are necessary to reach the desired result, and then papering the file with legal rhetoric afterwards. The goal isn't neutral adjudication. The goal is victory. The most obvious example is the abuse of nationwide injunctions. During President Trump's first term, lower courts issued 64 nationwide injunctions, more than all prior modern administrations combined. Then, after Trump returned to office in January 2025, district courts escalated even further, issuing 39 additional nationwide injunctions in less than a year, freezing major federal policies almost as soon as they were announced. Single district judges were effectively setting national policy. It wasn't until the Supreme Court intervened in Trump v. Casa that this practice was finally curtailed. Many of those injunctions were eventually narrowed or overturned on appeal. But that was beside the point. By then, policies had been stalled for months. Bureaucracies had regrouped, media narratives had solidified, and the administration had to burn enormous political capital just trying to govern. Delay and narrative was the strategy. You see the same tactic in individual trial court injunctions that slowed the Trump administration down and generated headlines useful to the progressive cause, but are not serious legal decisions that are expected to hold up. Take the recent case where a federal judge temporarily barred ICE from using tear gas and crowd-controlled projectiles. The ruling was immediately framed in the press as a sweeping judicial rebuke of federal enforcement tactics, even though it is a short-term restraining order and the kind of ruling that predictably got halted on appeal. Another example, last year a federal district judge blocked major parts of Trump's executive order restricting diversity, equity, and inclusion programs across federal agencies and contractors. The ruling produced instant headlines claiming the court had declared the orders were unlawful. But earlier this month, the Fourth Circuit Court of Appeals stepped in and reversed course, allowing the administration to move forward on removing these DEI programs. So again, trial courts issue a broad progressive ruling. The media runs with it, and the administration is forced into delay and legal and media defense. And only later does an appellate court quietly clean it up. That's the tactic. Lower courts create immediate disruption and narrative advantage even when their decisions won't survive review. At this point, someone is going to object. Hold on. Conservatives are winning. Roe was overturned. Chevron deference is gone. The Supreme Court is clearly more conservative than it was 20 years ago. So how can originalism be a dead end? Let's take that objection seriously. Yes, originalism delivers some victories. You see it in Dobbs v. Jackson, which finally reversed Roe and returned abortion policy to the states. You see it in Looper Bright Enterprises versus Raimondo, which ended Chevron deference and reined in the administrative state. These are real, meaningful achievements. But here's the problem. Originalism produces highlight reel wins. Progressivism produces institutional momentum. Dobbs didn't end abortion. It handed the issue back to legislatures, where progressives immediately regrouped, rewrote statutes, funded ballot initiatives, and mobilized courts again. Ending Chevron didn't dismantle the administrative state. Agencies are already adapting, reissuing rules, changing procedures, and daring challengers to start the litigation cycle all over again. Each conservative victory resets the board. Each progressive maneuver advances the game. That's the structural flaw. Originalism and other conservative judicial techniques are optimized for appellate correctness, not strategic dominance. It waits for the perfect case. It rules narrowly. It avoids sweeping doctrine. It respects institutional boundaries and assumes everyone else is playing the same game. But the other side isn't trying to win cleanly. They're trying to exhaust you. They use district courts to stall executive action. They exploit procedural rules to slow implementation. They flood agencies with lawsuits. They weaponize injunctions and class action lawsuits. They leverage media narratives while appeals grind forward. Even when they lose, they burn time, drain energy, and force conservatives to govern with one hand tied behind their back. So yes, originalism can deliver landmark opinions, but it cannot deter abuse. It cannot discipline lower courts. It cannot stop delay tactics, and it cannot impose costs on bad faith actors. Now, someone will point to Trump v. Casa, where the Supreme Court finally curtailed the practice of nationwide injunctions. And agreed, that was a real victory. I'm not dismissing it. But consider what it took to get there. For years, district judges issued dozens of nationwide injunctions freezing major federal policy. And when President Trump returned to office, they escalated further. Single district judges were effectively setting national policy. And where were the appellate courts? Circuits with conservative majorities could have moved more aggressively to curtail this abuse far earlier. They had the tools, but they chose restraint. By the time the Supreme Court finally acted in Casa, administrations had burned years of political capital. Policies had been stalled through entire terms. Bureaucracies had regrouped, and media narratives had solidified. The progressive playbook had achieved exactly what it was designed to achieve. The ruling came, but the damage was already done. And here's a deeper concern. Does anyone seriously believe progressive judges will simply accept this and stop? They won't. They'll adapt. They'll pivot to new procedural tools, new forms of obstruction, new ways to weaponize the judiciary for delay and narrative advantage. That's what they've always done. If conservative judges treat Casa as the final word rather than one battle in an ongoing war, if they go back to sleep thinking the system corrected itself, the victory will prove hollow. The system doesn't correct itself. It took years too long to respond to an obvious abuse, and it will take years too long again unless conservative judges adopt a posture of active vigilance rather than passive restraint. That's the pattern. Conservatives wait for the perfect case, rule correctly, and declare victory, while the other side has already moved on to the next tactic. In an ideological war, batting averages matter more than highlight reels. And originalism structurally caps conservative batting average. It gives you occasional Supreme Court victories while allowing thousands of smaller losses to pile up underneath. Progressives understand this. That's why they're happy to lose some cases, because they're winning the war. Now, I covered some of this ground earlier when I described how originalism emerged in response to the Warren and Burger courts, but I want to come back to it from a different angle, because this point is crucial to what comes next. In one sense, originalism isn't new at all. You don't actually need a philosophy called originalism to understand that statutes mean what they meant when they were passed, or that constitutional language has fixed content. That's simply how legal interpretation works. You read the text to figure out what it means. You don't update it to match social trends. That principle was always baked into law. Roman law assumed it. The common law assumed it. Early American courts assumed it. William Blackstone, whose Commentaries on the Laws of England was the most influential legal text in the founding era, described the judge's task as discovering the will of the legislature as expressed in the words of the statute, interpreted according to their known and established meaning. That wasn't a philosophy. That was just what interpretation meant. Nobody needed to give a name because there was no competing alternative. Judges didn't ask what words should mean today. They asked what they meant when they were enacted. So when conservatives talk about originalism as a return to tradition, there's truth in that, but only in this limited sense. Originalism didn't invent original meaning. It gave a name to something that had always been inherent in the act of judging, something so assumed it never needed a label. And it only needed that label because, as we talked about earlier, by the mid-20th century, courts had started abandoning that baseline altogether. So what I want to focus on now is what else was lost in the process. Because originalism didn't just name the old approach, it redefined it. And in doing so, it left out something essential. Classical judging was never just about fidelity to the written word. Yes, judges applied statutes as written. Yes, they respected original meaning. But that was only the starting point. Historically, judges were understood to be administering justice. They were expected to exercise prudence. They reasoned morally. They considered the social consequences of their decisions. They were responsible for preserving order and advancing the good within the framework of the law. They were not expected to be outcome agnostic. They were not expected to suppress moral judgment. They were not trained to behave like neutral technicians servicing a legal machine. Law was a tool, but justice was the end. You see this in the founding generation itself. In the Federalist Papers number 78, Alexander Hamilton described the judiciary as possessing neither force nor will, but merely judgment. But what's often missed is that Hamilton did not mean judgment as the mechanical procedure. He meant moral and practical discernment, exercised by judges of character. Hamilton emphasized that courts required integrity and moderation, and warned that without virtue, judicial independence becomes dangerous. The entire premise of judicial review assumed that judges would bring wisdom, restraint, and moral seriousness to their task, not that they would behave like value-neutral algorithms. But this wasn't unique to the American founders. It was the dominant understanding of the judge's role across Western civilization. Aristotle argued in Nicomachean Ethics that the judge exists as living justice, a person whose role is to restore the equitable and the fair, not to mechanically apply rules without regard to their purpose. Aristotle understood that written law cannot anticipate every situation, and the judge's task is to apply the law in a way that honors its animating purpose, which is justice itself. Cicero described the magistrate as the speaking law, and the law as the silent magistrate, each giving life to the other. The judge's job was not simply to enforce whatever the legislature produced, but to apply law in light of the justice it was supposed to serve. In On the Laws, he was clear. Law that contradicts justice may carry the force of the state, but it lacks moral authority. Now, someone might object, Aristotle and Cicero lived in worlds with relatively few written statutes, so of course judging involved moral reasoning. Judges had no choice. That's a very different situation from today, where judges are drowning in statutory and regulatory texts. But that objection doesn't hold up. Roman law was in fact enormously detailed and codified. The Corpus Juris Civilis alone ran over 1 million words. English common law by Blackstone's era was vast. American statutory law expanded relentlessly through the 19th century. The volume of written law grew dramatically across centuries, and the understanding of the judge as a moral reasoner persisted through all of it. What changed in the 20th century wasn't necessarily the amount of law, it was the philosophy of what judging was supposed to do with it. Judges didn't imagine themselves as free-floating legislatures, but neither did they pretend the law interpreted itself. They understood that interpretation always involved judgment. They understood that legal reasoning required wisdom, and they understood that their legitimacy came not from procedural neutrality, but from fidelity to justice. This is the tradition originalism claims to restore, but it only restored half of it. It recovers the commitment to original meaning, but it strips away the moral reasoning, the prudential judgment, and the orientation towards justice and the good that were always part of the judge's role. And that makes originalism not a return to tradition, but something genuinely new. So what did originalism put in place of that moral core? It installed a theory of judicial legitimacy grounded in suppressing substantive judgment. It tells judges they must avoid advancing any vision of the good, that law exists primarily to stabilize disagreement in a pluralistic society rather than to uphold moral order. That isn't classical judging, that's Enlightenment liberalism. This is why originalism, despite its conservative branding, quietly accepts the liberal premise that society contains competing moral visions, which the state must neutrally referee, and trains judges accordingly. In the War of Ideas terms, originalism leaves conservatives fighting conservative and Christian enemies while standing on liberal ground. Think about what that means. Conservative judges are supposed to be our institutional champions, appointed to defend a vision of society rooted in moral truth, natural law, and the Western and Christian traditions that built this civilization. They are there to contest the progressive and post-Marxist worldviews that now dominate so much of the academy, the government, and yes, the judiciary itself. That is the fight they are in, whether they acknowledge it or not. But originalism hands our champions a rulebook written by the other side. It tells them to fight on ground chosen by liberal philosophy, using a framework specifically designed to ensure that no one can advance a substantive vision of the good from the bench. It trains them to suppress the very convictions that they are appointed to defend. Of course they are ineffective. They have been disarmed by their own training. You can hear this in the way originalist judges talk about their own work. Justice Scalia famously said that a judge who likes every result he reaches is probably a bad judge, that a good judge applies the law even when he personally disagrees with the outcome. That sounds noble until you take a step back for a second. If you are knowingly issuing decisions you believe are unjust, destructive, or socially corrosive, that isn't a virtue. That is choosing stability over justice. It's choosing procedural legitimacy over moral truth. It's privileging institutional calm over human flourishing. Only a liberal framework would treat that as admirable. In the classical tradition, in Aristotle, in Cicero, in Aquinas, in the common law itself, laws exist to promote virtue, restrain vice, protect the innocent, and punish evil. Judges were expected to participate in that project. They were not praised for enforcing injustice with a straight face. But there's a deeper problem still. Neutrality doesn't actually exist. Suppressing moral judgment is itself a moral choice. Refusing to advance the good is still advancing a vision of the good, just a liberal one. Treating all moral claims as equally contestable is not neutral. It's Enlightenment liberalism in disguise. So when originalism tells judges to be neutral, it isn't removing ideology from judging. It's installing liberal ideology while pretending not to. That's the sleight of hand. Sophisticated thinkers like Scalia probably understood this at some level, but many conservatives today have been so thoroughly trained inside the liberal framework that they genuinely believe neutrality is possible. They think there's a morally empty position above the conflict. There isn't. That idea is liberal propaganda, absorbed so deeply it feels like common sense. So once you see this, the choice is no longer between neutral judging and political judging. The choice is between honest moral judgment and hidden liberalism. One side, progressives, wields judicial power consciously. The other side, conservatives, hides behind method. That's not restraint. That's unilateral disarmament. So I've done my part to deconstruct originalism and the broader approach to conservative jurisprudence. It's a departure from tradition, it's deeply liberal, and ideological even when people don't think it is. And it strategically disarms conservative judges who, like it or not, are ideological actors on the front line of the war of ideas. It's only fair to ask at this point, fine, originalism is fatally flawed and a strategic dead end. So, what should replace it? But before we can discuss that, we have to start with first principles and answer the question at the heart of this. What is law actually for? We've already seen that classical judges understood themselves to be administering justice, not merely parsing texts. But why? What was the underlying theory? What did they believe law existed to accomplish? In the classical tradition, law was never understood as a neutral traffic system for competing preferences. It was understood as a moral instrument, ordered towards the good. Aristotle put it plainly. In politics, he argued that the law exists not merely to prevent people from harming one another, but to make them good. The purpose of political community, and the laws that govern it, is to cultivate virtue and enable human flourishing. A society that only prevents injustice without actively promoting the good life has, in Aristotle's view, failed in its essential purpose. Cicero grounded this in nature itself. In On the Laws, he argued that true law is right reason, rooted in nature, commanding what is right and forbidding what is wrong. Law that contradicts justice may carry the force of statute, but again, it does not carry moral authority. For Cicero, the purpose of law is to align human society with a natural moral order. St. Thomas Aquinas synthesized and extended this tradition. He defined law as an ordinance of reason made for the common good by those with authority and promulgated. Every part of that matters. Law is rational. Law serves the common good. Law is authoritative. And law is meant to be known. But most importantly, law exists to shape human behavior towards virtue. This is not a fringe position. This is the dominant understanding of law across most of Western civilization. From Athens to Rome, to medieval Christendom, to the early American Republic, law was understood to promote justice, protect truth, encourage virtue, restrain vice, safeguard the innocent, and punish evil. It existed to order society towards human flourishing, not merely to manage disagreement. And freedom itself was understood this way. Not freedom as license, not freedom as autonomy detached from responsibility, but freedom as the capacity to choose the good. Laws exist to make that possible. Good law teaches, it forms habits, it reinforces moral boundaries, it creates conditions where families can thrive, communities can cohere, and people can live meaningful lives. It does not pretend to be morally neutral. It openly prefers virtue over vice, order over chaos, responsibility over indulgence. Stability matters, but only as a tool. A society can be perfectly stable while becoming spiritually hollow, morally confused, and civilizationally exhausted. A society like that is not successful. That's a managed decline. If this is what the law is for, if its purpose is to cultivate virtue, protect the good, and order society towards human flourishing, then a legal philosophy built on procedural neutrality is not just strategically weak, it's a fundamental mismatch with the nature of law itself. Progressives, whatever their other failures, understand the law is a tool for shaping society, and they use it that way openly. Conservatives trained in originalism respond by defending process and method. One side is trying to shape civilization. The other is trying to preserve the rule book. That's not a fair fight. So what should replace originalism and the broader conservative approach to jurisprudence? I call it classical jurisprudence because for most of Western legal history, judges were understood to apply binding law while exercising moral judgment, prudence, and responsibility for the social order. Again, they weren't neutral technicians. They were stewards of justice. And let's be honest about something. What conservatives actually hated about the Warren Court and the Burger Court wasn't the methodology. It was the progressive, non-democratic outcomes. The real objection was never, judges are exercising discretion. It really was, judges are exercising discretion in the wrong direction. So here's what I'm proposing. First, statutes remain binding. Judges are not legislators. They cannot ignore text. They cannot rewrite laws, and they cannot invent authority that does not exist. The plain meaning of written law still constrains outcomes. This is not optional. A system where judges treat statutes as suggestions is not a legal system. It's raw power. But statutes do not interpret themselves. Every act of judging involves discretion, emphasis, and moral judgment, whether we admit it or not. This is the reality that legal realists correctly identified a century ago, and it's a reality originalism has tried to paper over ever since. So instead of pretending judges can be neutral, we should be honest about what judging actually requires. Here's the key concept. In virtually every case that matters, there's a zone of interpretive discretion, a space where the text honestly supports more than one plausible reading. This is not judicial invention. It's the inherent nature of applying general language to specific facts. Originalism pretends this zone can be navigated neutrally. Progressive activism pretends the zone is essentially unlimited. Both are wrong. Classical jurisprudence says the zone is real. It's bounded by text, and within it, judges should orient their discretion towards justice and civilizational goods, rather than pretending they're making no choice at all. This is not judicial activism. Activism ignores the text. It treats law as raw material for judges to reshape according to their preferences. What I'm describing is different in kind. It takes the text seriously, identifies a range of honest readings it supports, and then selects among those honest readings based upon which one best serves the good. The tether to plain meaning is what separates this from activism. And the honesty about the moral judgment within that tether is what separates this from originalism. What does this look like in practice? Judges should begin by identifying the purpose of the statute or constitutional provision. What human good is it meant to serve? Public order? Family integrity? Religious liberty? National sovereignty? Protection of children? Respect for life? These are not abstract technicalities. They are civilizational goods. Judges should also assess civilizational impact. Law does not operate in a vacuum. Decisions shape institutions, incentives, culture, and behavior. Conservative judges should stop pretending their rulings are morally weightless. They aren't. From there, application follows. If a statute advances conservative or natural law goods, judges should interpret it broadly and charitably within the bounds of honesty. Ambiguity should be resolved in favor of those ends. The law's purpose should be reinforced, not hollowed out by hostile construction. If a statute advances progressive outcomes, radical autonomy, erosion of parental rights, dissolution of moral boundaries, judges should apply it narrowly and skeptically, enforcing it only as far as the plain text absolutely requires. No creative extensions, no expansive readings. The law still binds, but interpretation serves justice. It's what the common law tradition practiced for centuries. judges reasoning within precedent and statute, but always with an eye towards equity, the common good, and the just result. This alone would dramatically increase the conservative batting average without abandoning legal discipline. But there's more, and here I want to be honest that I'm expanding the frame. What I've been discussing so far is originalism as an interpretive method, how judges read and apply text. But originalism as a method exists within a broader conservative judicial posture, a set of habits, instincts, and self-imposed restraints that shape how conservative judges behave on the bench. These include judicial minimalism, reluctance to use institutional power, and a general disposition towards deference and passivity. These habits overlap heavily with originalism and are reinforced by it, but they extend beyond interpretive theory into how conservative judges wield, or refuse to wield, their actual authority within the judiciary. Classical jurisprudence has to address both, because fixing the interpretive method while leaving the broader posture unchanged will produce the same results. And that broader posture needs to change too. Courts must become comfortable using institutional muscle. That means, first, disciplining abusive lawfare, cracking down on coordinated litigation campaigns designed to stall governance through procedural abuse rather than advancing serious legal claims. But it also means something more significant. Appellate courts must use their supervisory authority over lower courts. As I documented earlier in this episode, the progressive playbook depends on district judges issuing transparently outcome-driven rulings, nationwide injunctions, sweeping restraining orders, headline-grabbing declarations that are designed not to survive appeal, but to create delay and narrative advantage. The strategy works because there are no consequences. A district judge issues a clearly erroneous injunction, policy is frozen for months, media runs with the story, and when the appellate court finally overturns it, the damage is already done and the judge faces no repercussions. That has to change. Appellate courts have tools they rarely use: writs of mandamus, reassignment of cases from judges who have demonstrated patterns of abuse, pointed opinions that create real reputational costs. Conservative judges need to stop treating these tools as impolite. When a district judge issues an injunction that is plainly unsupported by the law and designed to obstruct rather than adjudicate, appellate courts should say so explicitly and act accordingly. The lack of consequences is what makes the tactic endlessly repeatable. And conservative judges need to stop hiding behind judicial minimalism when foundational questions are staring them in the face. Resolving major constitutional questions when they arrive, rather than ducking them through narrow rulings while lower courts sabotage governance for years, is not judicial overreach. It's the court's job. That doesn't mean replace legislatures or executives. Real change still requires conservatives to win elections, pass laws, and govern well. Courts cannot move the baseline on their own. But judges must stop acting like passive referees while one side uses the judiciary as a weapon. Now, I want to be clear about what this framework is not. This is not a call to fight fire with fire. Fully unmoored judicial warfare, where conservative judges simply mirror progressive tactics, ignoring text and inventing authority, would actually accelerate institutional collapse. Even if that means progressives retain some asymmetric advantage in the short term, there is no alternative. Saving the heart by killing the patient is not acceptable. Law must remain binding. Judging must remain disciplined. But neutrality must be abandoned. Justice must return to its proper place. So in closing, originalism solved yesterday's problem. It helped rein in mid-century judicial excess. It restored respect for text. It slowed some of the worst abuses of the Warren and Burger Court era. But we don't live in that world anymore. Today, we are facing something much bigger than interpretive drift. We are in a civilizational struggle over truth, morality, family, sovereignty, and the future of our society. And procedural neutrality is not an adequate response to that. What we need now is a new conservative legal project, one that trains future lawyers and judges not just in method, but in moral reasoning, civilizational awareness, and the honest exercise of judicial power. And more importantly, conservatives need to be honest about the stakes in this war of ideas. We need judges who understand that they are ideological actors, whether they want to be or not, that every decision they make shapes culture, institutions, and incentives, and that hiding behind method does not absolve them of responsibility. Further, we need legislatures that actually govern instead of outsourcing hard questions to courts. And we need executives who are willing to enforce the law instead of managing decline. Otherwise, we'll keep celebrating narrow procedural victories while losing the future. In my last episode, I talked about how the conservative coalition itself is fractured because conservatives fundamentally disagree about the use of state power and what they're fighting for. Many on the right treat power as inherently suspect, as a moral hazard to be avoided whenever possible. They default to wariness. They worry about becoming what they oppose. Let's be clear, the left does not share that hesitation. They use power with glee. So conservatives end up tying their own hands, while progressives use every institution available to them to implement their agenda. Judges mirror the same pattern. Conservative judges emphasize restraint, honest methodology, and neutrality, while progressive judges pursue outcomes directly and then create legalistic-sounding rhetoric to cover their tracks. One side fears the sword, the other confidently wields it. But here's the truth. The sword of government is dangerous, and it always has been. But the answer to that danger is not abdication. The answer is virtue. Power in the wrong hands is catastrophic, but power abandoned is no better. Abdicating responsibility is not the moral choice because it prioritizes your own scruples while abandoning the people who depend on you. The goal is not to destroy institutions, and it's not to become tyrants. It's not to mirror progressive excess and wield power with wild abandon. The goal is to govern faithfully, to judge prudentially, and to pursue justice for the common good and the flourishing of our people. That's what classical jurisprudence is trying to recover. Our model shouldn't be the modern libertarian like Ron Paul, who talks endlessly about liberty while accomplishing nothing except paving the way towards total victory for progressives. Our model should be Cincinnatus. When the Roman Republic was in grave danger, Cincinnatus did not flee from power. He accepted command. He ruled with discipline and restraint. He saved his people. And when the crisis had passed, he did not cling to authority. He relinquished it and returned to his farm. That's the balance. Strength without tyranny, authority without corruption, power exercised for the sake of justice, and then surrendered. That's what we need now, in our courts, in our legislatures, and in our executive leadership. Because civilizations do not preserve themselves, and justice doesn't enforce itself. Originalism helps us survive one era, but it won't be enough to win the war of ideas. The future belongs to conservatives who are willing to pick up the sword of government and govern. Not recklessly, not vindictively, but courageously, prudentially, and with moral clarity. And pretending otherwise is how you lose everything. You've been listening to the Restless Signal podcast, copyright 2026, all rights reserved. Check us out on the web at warofideas.com.